Okay, I will start the last day of our hearings with our karakia. Whakataka te hau ki te uru, whakataka te hau ki te taona. Kia mā kinakina ki uta, kia mā tarata ki tai, kia he ake ana te atakura, he tio, he hoka, he hauhu, te hei, nori ura.
Well, tēnā koutou katoa. Welcome everybody. Last day of the last hearing. Welcome back. It's been quite a journey since May last year. We have as our first submitter today, Paradise Ground Developments Limited, and welcome Mr. Dawson and Mr. Hook here. Mr. Dawson, you've got some legal submissions to distribute.
Yes, I do.
Give back to Alicia Kate and she'll distribute those. Now we've pre-read the evidence and the rebuttal, so thank you for pre-circulating that. So I guess it'll be like this is reconvening hearing 15B, although we're at hearing 17. The hearing panel for 15B is Councillor Foy, myself, and Commissioner Watson. You can see Commissioner Smith is at the table, but he will be participating in this particular hearing. Right. He's not part of 15B hearing.
Right.
He makes us look good, so.
Kind of balances out the table, but. Good morning, Commissioners, Council staff. First of all, I'd like to thank the panel for accommodating us on the last day of all of these hearings. It was quite an unfortunate circumstance we found ourselves in, so thank you for that accommodation. I understand that you did a site visit yesterday?
Yes, we did. We arrived at the site in very thick fog, and we thought that the site visit was going to be at 3 metres at a time. Unfortunately, as we got onto the property, it sort of lifted like a curtain in a theatre, and we ended up having a site visit. We were ably assisted by Mr. Sterling around the property.
Good. All right, so these submissions are made on behalf of Paradise Found Developments Limited, and they of course address their property known as Wīroa Station. I'm sure, Commissioners, that you're familiar with the statutory assessments you're required to undertake, and with the evaluation of evidence, and recognise that your decisions made in this forum must be informed by the weight and probative value of the evidence presented to you. In this instance, the council officer, sorry, there's a typo there, has presented a thorough and considered evaluation of my client's submissions in his section 42A report and supplementary report. Mr. Hook's expert evidence has been carefully considered in its preparation, and it is evident that there is a great deal of commonality and agreement between these two experts. Both agree that given the consenting history of the property, which I should say is fairly complex but thorough, the previous assessments undertaken and baseline of development, that a precinct is an appropriate planning response for Wīroa Station. Given the weight of that expert evidence, then, it is appropriate that my comments and my client's evidence focuses on the points on which Messrs. Wade and Hook disagree. Those aspects are each discrete and well defined. Just pausing there, I'm not going to, go over all of the consenting history and reasons why a special zone and all of that stuff. So I hope you're not disappointed by that. But given that the commonality, it seems appropriate just to focus on the points of disagreement. Briefly, the background's been summarised, but there are several resource consents that have been granted over many years to Wīroa Station, enabling the development and subdivision of the property, and the principal one of which I've listed there And that would have been evident from your site visit, of course. I mean, a lot of it's been done. All the titles have been created. The common facilities are in place. The wine cellar, tennis court and beach bungalows are all there. So Wedora Station is a comprehensive development of 21 lots, comprising some almost 90 hectares. Residential development, in my view, is consented on those lots, 20 of which are around about 4,000 square metres each. The balance of the property, comprising lot 14, is 88.5 hectares, and it is held for its farm and conservation and ecological value. At present, 3 lots have been sold, with dwellings having been completed on 2 of those. You would have noticed, I'm sure, yesterday, 1 currently under construction. The common facilities such as roading and so forth have all been completed. My client, or entities related, owns the balance of the property. In other words, the significant majority of it, and thus the reason for the submitter. Whilst the earlier consents have been completed, such as the subdivision itself, or otherwise given effect to and remain live, in my view, there are aspects of the proposed district plan as notified that cause potential difficulties. Thus the reason for my client's submission. At the outset, it is accepted that Mrs. Wyeth and Hook both agree that the earlier consents provide a recognised baseline of development that should be appropriately recognised in the proposed district plan. Consequently, the issues on which I'm going to comment are the permitted activity pathway for buildings and structures on identified platforms and residential lots. So we say those should be permitted. Council Officer says no, those should require a controlled activity consent. And the second aspect on which there's a little bit of disagreement is the provision of helicopter movements and landing. So first of all, just running through the permitted activity status, as you'll be familiar, there are 600 square metre nominal building platforms that are embodied in the underlying subdivision consent, and they're shown on each one of the 20 vacant lots as the approved plans. Future dwellings are subject under the subdivision consent secured by consent notices. They're subject to rigorous design controls and certification, individual maximum height levels on each lot, infrastructure and engineering requirements, and also lead to that mitigation and enhancement planter. So it's quite comprehensive. Looking through the underlying subdivision consent, I note Advice Note 5 comments on this, and I've quoted it there, but the salient comment is that it records that Council is satisfied that for the purposes of the district plan, that's of course the operative district plan, rule relating to visual amenity, approval of the subdivision and creation of the titles in accordance establishes building envelopes approved under resource consent for the associated lots. Of relevance too, the decision specifically records that the effects of the proposal on local landscape, amenity and natural character value are regarded as less than minor for the following reasons. And then it lists several rationales. Commissioners, the importance of that is, I think, 2 things. First of all, it establishes the reason why the 2 planning experts concur that there's a baseline of development, an anticipated level of development that's consented here. But it's important for another reason, and it goes to the rigour and the scope of the consents that were granted and that now provide that baseline. As you'll be aware, of course, the underlying subdivision consent resulted in both bespoke site-specific controls, including as the maximum height, a nominated building location, architectural guidelines that need to be satisfied for each lot, and detailed planting. In all then, in my submission, there was a robust assessment of core landscape values and visual effects, secure and comprehensive design outcomes for buildings and dwellings. Mr. Hook and Mr. Wyeth both agree that there is an anticipated level of development as such and a conservation outcome that's secured. And Mr. Wyeth specifically notes in his report that it is evident that development at Weaverell Station has been subject to a detailed assessment through the subdivision consent process with a suite of controls to ensure that future development is carefully designed to be consistent with the ecological, natural character and landscape outcomes sought. On the basis of this, Mr. Hook's evidence and his opinion to you is that a permitted activity status is appropriate, and that's recorded in proposed rule 1 for new buildings and structures, including some provision for extension and alterations, where those buildings and structures are located to take advantage of the nominal building platforms. This is consistent with the underlying subdivision controls and consent notices. However, it is at this point that Mr. Hook and Mr. Wyeth part company, where Mr. Wyeth considers that a controlled activity status for new dwellings and buildings, even though they're relying on those nominated building platforms, should be required. And he states several reasons. First of all, Mr. Wyeth seems to be concerned about consistency and his recommendations elsewhere, notably to Manukau Station and the landing. And I will say that whilst I wasn't at those hearings, obviously, I have reviewed the hearing tapes, videos, so I do understand what the rationale was there. Whilst I appreciate Mr. Wyeth's desire to be professionally consistent and the integrity of needing to do that, that nonetheless does not preclude you as the panel from reaching a different decision. Fundamentally though, I'm not at all clear how or even if consistency comes into the evaluation criteria in section 32 of the Act. I don't think it does. Just pausing there. I understand this, I often hear this, council saying, well, you know, we need to be consistent in our district plan so that everybody understands the rules. Understand that, but in this instance, as with the landing in Manukau and one or two others, we are talking about a special zone or precincts or special provisions. In other words, we're talking about an exception. So, to be frank, I'm not convinced that the desire for consistency in the proposed district plan provisions is actually relevant under section 32 of the Act. Really though, looking through Mr. Wade's report, his reservations seem to come down to how the council might manage assessing compliance with a permitted activity rule and the related performance standards without actually requiring a resource consent application to be made. That, with the greatest of respect, is most certainly not a valid or relevant consideration for you or indeed for him under the Act. There are many reasons why I say that, the most compelling of which is that council is obliged to assess compliance with the district plan provisions, whether or not, as in this instance, it is faced with a resource consent application or an application for building consent. Just pausing there, council has an obligation to enforce its district plan. Landowners have to comply with it, people have to comply with it. Nowhere does it say, and oh, by the way, you need to apply for a resource consent or a certificate of compliance before you do anything. That isn't the case at all. In this instance, though, building consents will of course be required, and consequently, either through the building consent process or a resource consent process, a robust assessment process is required, under which council is presumed and enabled to assess compliance. and has more than sufficient opportunity to request and then assess any information it requires to achieve that. The provision of a compliance report prepared by a suitably qualified person, and this is reflected in Mr Hook's proposed rule, overcomes any so-called wide-ranging and relevant technical matters within the permitted activity rules. I'm talking there about specifically compliance with the design guidelines and with the infrastructure requirements. So council would be provided with those two things. The building consent application would need to demonstrate compliance. So in other words, what's left? Frankly, then I find it ridiculous to suggest that council cannot determine compliance with district plan standards when faced with a building consent application rather than a resource consent application, when actually the council has a statutory obligation to determine compliance under either. Mr White suggests that a permitted activity framework for new residential dwellings was not provided for or anticipated when the subdivision consents for Wheelwright Station were granted, and he says that that makes the provision of a controlled activity status now appropriate. With respect, though, the relevant inquiry of you under section 32 of the Act turns on whether the proposed activity classification is the most appropriate way to achieve the purpose of the Act. You guys know this, you've been hearing it for months. That's what we're here talking about. And in so doing, to promote sustainable management of natural and physical resources. That, of course, is the purpose of the Act. Here, over multiple consents, over many years, the council has diligently assessed the effects of the Wheelwright Station development, including the built form that is an inevitable consequence of subdivision. That is the reason why a robust set of building and design controls are secured over the subdivision, because the development is both anticipated, inevitable, and appropriate. In other words, the sustainable management of this property has already been assessed again and again and again and consented. Nowhere in Mr White's report do we find any comment as to why the assessment was deficient, because even he acknowledges it wasn't, or how a further assessment and consent process through a controlled activity could possibly be expected to add anything to the outcome. He agrees that a detailed assessment has already been completed and that it is assured that future development is carefully designed to be consistent with the ecological, natural character and landscape outcomes sought at Wheelwright Station and deemed appropriate. That begs the question then, quite frankly, what more could the council ask for? The purpose of the Act was achieved when those consents were granted in council's view, and in my submission, nothing at all has changed. He then goes on to note that a controlled activity status should not be overly onerous or costly, and it is largely about consistent compliance. Importantly, he acknowledges, and quite appropriately of him to do this, but it's not about re-litigating or questioning the appropriateness of residential dwellings. Helpfully, and Mr White helpfully and very appropriately acknowledges that the purpose of a controlled activity status is largely to assess compliance rather than to complete an assessment afresh. If compliance can be assessed more efficiently elsewhere through the building consent process, why then, I would ask you, is another resource consent process needed exactly? And just pausing there, Mr Hook has commented on this. If there was a controlled activity status, what are the conditions that council could reasonably be expected to impose that haven't already been dealt with? The building footprint, and location in a sensitive area, that's already been determined. The maximum height, that's already been determined. What these buildings are going to look like and their functional form and all those architectural design things, those are taken care of. Infrastructure, wastewater, stormwater servicing, that's been dealt with. Planting, that's been dealt with. So the only condition that I can anticipate that council could possibly think about imposing would be one that says you must comply with the underlying consent conditions embodied in your consent notice. But in the meantime, we've had a process and a cost and risk for the applicant. What realistically does it achieve, or is this just an instance of planning for planning's sake? So that's all I've got to say about that issue. Just turning to the helicopter movements rule, which seems to have become a point of debate, albeit actually fairly minor, between our two planning experts. But Mr. Wyeth seems to be concerned that helicopter movements do not form part of the consented and anticipated development at Wee Station. And thus, Mr. Hook proposing a permitted activity rule for helicopter movements is not appropriate. And I note here that when you work through Mr. Hook's evidence, it's not just a permitted activity rule. There are several criteria that need to be met as performance standards, and they result in a very restricted location or locations in which helicopters could land as permitted activity. However, as Mr. Hook goes through, helicopter movements can occur at Wee Station as a permitted activity under the operative district plan at the moment, subject of course to compliance with the noise provisions and standards. All that Mr. Hook is now proposing in his evidence, quite appropriately in my view, is an equivalent in activity status and scope to the operative rules, whilst also setting a more rigid and clear framework for operational requirements in the proposed district plan. Mr. Hook goes on to deal with other drafting issues which I think are important but fairly minor. Overall, these are intended to ensure consistency of the current suite of consents and consistency between the two. The operative district plan and the thorough expert assessments have already been undertaken. I leave it to him to address all of those with you. In conclusion then, there was a high degree of accord between Mrs. Hook and White, and that is the expert evidence upon which your decision, of course, must be made. They diverge in some aspects of the proposed rules, but the principal area of difference is as to the activity status of future dwellings and buildings on the lot. Those dwellings are an inevitable consequence, as I've said, of the underlying consents and the rigid controls imposed therein. Further consenting process, in my view, adds nothing to the outcome. So, although we're here on the last day of the hearings, we are thankfully in a position where there's a high degree of accord between the two planning experts. Hopefully that makes everybody's job easier. That completes my legal submissions to you. I'm sure you have some questions.
Yes, we may.
Well, maybe the question's probably better directed to the planning consultant, but I mean, just one question in terms of what you had to say. There's three properties that have been developed today. Well, what's been the process for them being developed? What's been the consenting?
I don't know, and I'm not sure that we do know. I wasn't involved with them, so I
But I can answer that question, yeah. They've gone through the operative Chapter 10 Coastal Environment Controlled Activity Rule for Visual Amenity, which is operative Rule 10.6.5.2.2, and that specifies a matter of range of considerations, matters for control, which are items like size, bulk and height of the building. relation to ridge lines and natural features, colours and reflectivity, extent to which planting can mitigate visual effects, those types of things that in my evidence, which I'll come to shortly, have already been addressed in both the original 2008 consent and then the major review of that in 2015. At both stages, consent notices, a very detailed consent notice has been applied to the property. Both instances, original and the refresh, landscape and visual effects on the coastal environment were considered in detail. Planting and restoration of those gullies and areas that you saw were planted, part and parcel of that whole process. The detailed plans that prepared by Boffa for each of the building platforms show planting not just within the existing lots but in the framework area surrounding them. The lots were originally 1 hectare, so the planting plan relates to a 1 hectare area around a building platform which is now 4,000 square metres, but just under. Those requirements are all sitting there as part of the consent notice framework for each of those sites.
They did go through a
They
control.
did go through a control activity consent, yes. Yeah.
It was just a similar line of questioning around the current general coastal zone. So essentially currently the dwellings needed a controlled activity consent because of the visual amenity rules.
Correct.
But then also in your evidence you're asking for under the new plan for it to be permitted, but then also asking for a permitted rule relating to the helicopters to then move over into the new plan as well.
So the operative coastal environment chapter has permitted activity rule for helicopters. It's helicopter landing area rule 10.6.5.1.11. It simply says helicopter landing area shall be at least 200 metres from the nearest boundary of any of the coastal residential, Russell Township or Point Veronica zones. It's a specific activity rule in the permitted activity section of the coastal environment chapter. It is then supported by a noise rule, which to be a permitted activity, of course, have to meet both the requirements of the noise rule and the permitted activity rule. It's identical in that sense to the framework that the precinct provisions encapsulate, whereby there is permitted activity status for helicopter landing, but whether you can establish that and use that right depends on whether you can meet, firstly, the standards for permitted activity, which in proposed precinct provisions are more specific and more rigid than the operative rule. And secondly, whether you can meet the general noise standard for helicopter takeoffs and landings. If you can't, then you fall into that special activity status. So really we're seeking in that part of my evidence to maintain the opportunity that exists currently and to put a more rigid framework around it in respect of this property so that it is clear that there is only one helicopter landing area, not an unlimited opportunity, and the specific location of that is defined by permitted activity standards under the proposed rule. So it's, I would say, equivalent but more tightly defined and controlled than the operative provisions in respect to helicopter landings.
Can I just comment on the conversation about the controlled activity consenting requirement under the currently operative plan for future dwellings? And not really sure that I can say it any more plainly than so what? I mean, the issue before you and the opportunity that a proposed district plan process creates is for the council, and of course now for you, to review the process and the rules and to say, well, are these the most appropriate, efficient and effective way of doing things? And I think the real point here is that that permitted activity status didn't seem to be available under the operative district plan. Frankly, I find that a bit confusing, but the real point is, given the controls that are in place over the properties at the moment, in the design and building location and all of that, the real question is, what is to be added by requiring a consent process now? Because the default position isn't everything should be consented. The default position under the Act is things are permitted unless we say otherwise. And that really is, in my view, that's the fundamental issue here, is it appropriate now, given the assessments and controls that need to be satisfied anyway?
I think a supplementary question to that was discussed yesterday with officers was essentially the assessment of the landscape plan and the building design, which we don't know the design until the building consent is applied for, and that the controlled activity pathway is to allow that assessment by an officer. Is this a suitably qualified landscape architect that's a suitable design, and as well in terms of the building design itself, fitting within that, as you know, it's a special landscape as well.
Well, I wouldn't have expected, if we talk about current consenting requirements at the moment, as a starting point, I would not have expected that the council would be in a position or inclined to critique or comment or even criticise a proposed build. We're talking about building design elements now, right? Not the location and height, not the envelope. We're talking about building design elements. When under the current consenting regime, the applicant has to go through a robust design process. They have to satisfy compliance with what is a very detailed set of architectural guidelines and certify that they have done so, and have that sign off. So, you know, I'm not really sure that, well, I wouldn't expect that under the current consenting process that council is really in the business of talking about building design elements, nor that opportunity is really there. So I'm afraid that leads me to the point that I don't agree that that's a relevant consideration under the proposed district plan, because the permitted rule, as Mr. Hulk has put forward, is that compliance with the design criteria, which are detailed and expert, needs to be certified by, you know, a suitably qualified person. And if council, there is an out there, of course, for council. If they say, well, you know, you've gone and employed somebody who has no architectural experience at all, and they're not a suitably qualified person, that's quite a different thing. But I wouldn't have expected in a development such as this that would arise as an issue. Does that make sense?
Each of the management plan subdivisions all have different internal processes, yes, by which of the design and landscaping criteria is signed off by the management plan subdivision committee itself.
Well, I think that's somewhere to go. Is who does the sign-off? I mean, who does? I mean, I understand that there is an architectural design guidance and landscape guidance. That's all enshrined in the consent notice, correct?
Yeah. Yes, correct.
And so, can you just tell us how that process works and who makes the decision? I mean, we know that in similar precincts such as Africa and the land, they actually have organisations within this company structure that do that meeting in various ways.
Yes. So it's an internal process, which is...
I mean, looking at it, it seems to me that someone designs something who's suitably qualified And does that mean somebody else who's suitably qualified certifies it?
Yes. So, yes.
And that one expert designs it, the other expert signs it off?
Well, and I mean,
Or is there, does it go before any residents, or is there a committee or organisation that has some sort of oversight?
well, there is a design under the, so we're talking about the current consent and requirements, right? As for wheelrow station, as reflected in the consent notices and so forth. And there is a design committee that these designs have to go through and be approved of by the committee. I'm just looking at it now. So the design committee is charged with doing that, and the committee comprises appointed by North Bay Holdings Limited, which is essentially a developer.
Chase, Mr. Dawson, there's no reference to that committee in precinct provisions. And so as I was reading through it, I think, well, who makes this? Who gives us the comfort that there is going to be a robust review of these things, and perhaps that could be actually stated in the precinct provisions.
Yes, so that
approved by this process.
Yes, so the subtlety is, and perhaps the drafting could be changed, but the under the proposed permitted rule, compliance with the wheelrow station architectural code is still required, and to assure council of compliance, because it would be a permitted activity rule, compliance is achieved by providing a sign-off from a suitably qualified person. So it's a twofold thing. So in other words, status quo, and the assurance for council that that's been done is there's a sign-off from a suitably qualified person, a certificate, like in the building parlance we'd call that a producer statement. So it's same.
So those consent notices are part of the existing environment.
Correct. Yes, I would agree
Those
with
consent
that.
notices allow a dwelling to be erected subject to that approval and appraisal process.
Amongst other controls, yes.
Because my understanding is that the entire site sits within the coastal environment overlay. And if there was no precinct, then those overlay provisions don't apply.
We'll
get to what your existing environment is.
Yeah.
Setting aside the existing environment at the moment, if you are in the coastal environment overlay, you'd be subject to that rule. And of course, you can rely on resource consent that says I can erect a dwelling on an identified building platform subject to my consent notice requirements. Is that the existing environment we have?
You're talking about the operative district plan.
We're talking about the existing environment that applies today.
Correct. And that seems to be the way that is the way that council's applied it to date, is you've got to comply with everything, and you also need a controlled activity consent under the visual amenity rule, because you're in the coastal environment.
Right. So
that isn't an existing environment though. The existing environment is what can be built there as of right.
it's right, under the consent that your client has, can they build a dwelling under the proposed rules? Now, the coastal environment chapter has a rule relating to development within the coastal environment. Now, this is a recommended rule that's been amended. Now, Mr. Wyeth, can you just, Mr. Wyeth was also the author of that section.
Yeah.
The recommended, where is the recommended rule for development within the coastal environment?
So it's rule CR1, CON 1.
Can we get that up on the screen or something?
Well, it would need to be the right of reply version of
Hearing four.
yeah, hearing four. Well, complex. And obviously, we're not assuming that you know this because obviously we're across all of the provisions. What I'm trying to understand is, if there were no precinct, what would be your default consent status to erect a dwelling? And how far does your resource consent take you with regards to what's been recommended in the coastal environment? Coastal environment rule, I understand, is anything within the coast, any building within the coastal environment is a controlled activity. Is that generally it, Mr. White?
Yes.
So,
It's generally the R1 rule that we have before us, the latest R1 recommended to us from European Council officers, is that dwellings in the coastal environment require controlled activity.
Correct. And it's been on an identified building platform where it's been subject to a professional landscape assessment for a subdivision consent.
And of course, this precinct then says that one doesn't apply.
Yes, correct.
Permitted at sea.
Yeah.
Yep.
And what I want to understand is, assuming those things apply now, that rule applies, and you don't have a precinct, does your resource consent allow you to erect those dwellings without having to comply with that rule?
That's a very good question.
It's the one that's been bouncing around in my head for a wee while, and I think that's the nub of the issue.
I 2 points to that. The first is that whether or not the underlying consents can prevail is the subject of very extensive legal advice.
Right.
And it's a similar situation at manifestation. My view is that those underlying consents, in fact, do prevail, and that the controlled activity status that Council is applying at the moment is not correct. But that's my view, and but the reason I give it is because when you look through at Wendouree Station, the scope of the applications that were made and the assessments with them, it's fairly clear to me that, well, I think it's very clear that it comprised three elements. One was a subdivision. That's been done because they've all got titles. Two was, common facilities and buildings. We've all seen those. But three, and the most important aspect, was that they anticipated and consented, because it anticipated, a building envelope. And that envelope is, just to put it simply, a 600 square metre rectangle to a maximum height of 5.5 or 7.5 metres, what it was. In other words, it's a cube. So within that, anticipated and consented was a building envelope. Those consents have been given effect to, and therefore remain live, because the subdivision's been done, and there's been so much done. So for that reason, I would actually say that under the operative process, Council should not actually be requiring a controlled activity consent.
But the Chair's question goes to the nub of the issue. If you're wanting to put a building on one of those sites now, what's preventing you doing that?
I don't think there is anything to it.
So why do you need a special zone or precinct?
Well, because for two reasons. One is because, well, actually for three reasons. One is because I've got my view of it legally, and until we go and sit in the High Court, the Court of Appeal, and argue it, it's going to be over to the people at the Council, so it's contentious. Two is because Far North District Council at the moment, as we've heard and as we've said, are requiring a controlled activity status, irrespective of what I might put on my letterhead and say. Who's going to listen to me, right? And the third reason is because it's a belt and braces thing. These are significant properties, significant investments, and my clients don't want to have to go through a consenting process again and again and again. When people spend a lot of money and think, well, we should be able to build a house here. I mean, what else are they buying it for? So that's the reason, Commissioner, is because of the uncertainty and because there are competing points of view, and we simply want to clarify it and have certainty going forward that, you know, you actually don't need to re-consent and re-litigate this whole thing to build a house.
Yeah, look, it seems to me, it seems to me that you conceded that it's uncertain, and I'm giving us your third legal opinion.
Yeah.
And I suspect Mr. Hook has a planning opinion that's not dissimilar. But you conceded that council officers may not agree and that there is a little bit of uncertainty. So certainly it seems to me that if we're going to approve a precinct, one of the things that we want to establish is certainty.
Yep.
And I think there are two routes for creating certainty: permitted activity route and controlled activity route. We're also considering this question of what provisions would apply in the coastal environment zone in any case. And it seems to be one of the options to us is if we think there needs to be some controlled activity oversight, it may just be a matter of removing the exemption of that rule under the coastal environment, and that provides a controlled activity ready-made. Or we could still exclude that rule and come up with our own. Or we accept your permitted baseline argument and accept, I guess, the vetting process that the consent order has is suitable under this proposed planning regime. I think those are the choices I think we've got.
Yeah, so, Mr. I just got to the first choice, which is it permitted or controlled? And how we draft that, or how you draft it, or how Mr. Holt drafts it, you guys can figure that out. I agree with you.
We all agree we need some certainty here.
Yeah, but the starting point is, are we going to make building and the existing approved envelopes, design controls within those permitted parameters, are we going to make that a permitted activity at Wheelrow Station? If we are, then Mr. Holt can advise us on the drafting.
Yeah, and I could obviously telegraph to Mr. Hook, perhaps if we could add something perhaps into those precinct provisions that give us a little bit more detail as to who does the approving, what their role is. That might give us some certainty about, it's just one expert's science and other experts' work. If it is subject to a committee made up of residents and landscape architect development, and that they effectively perform the role of an approval body, then and then we can look at the other two examples that we have and go, yes, that looks as robust as that, and that might be enough for us.
That might be right. And of course, it's important, though, isn't it? We sort of bear in mind the situation of a planner at the council when we're not there, 3 or 4 years' time on a Friday afternoon going, heck, what does all this mean?
Yeah, and I think
they need to understand it. And I agree with you, Commissioner, that perhaps the permitted rule as Mr. Holt's drafted it, putting that extra robustness into it could well assist.
Well, this looks like a nice segue to you, Mr. Hook. I mean, we've sort of stolen a bit of your thunder with the summary, but we're in your hands as to what extra evidence you're going to give us.
I'm very comfortable that we've dived into some of the live issues because maybe it's endeavoured to address those. Just starting with CER1 and the officer's recommendation to CER1. So CER1 is notified in the plan that submissions are made on as a discretionary activity status. Would apply to Wheelrow Station and those other sites where consented building platforms exist. The redrafting of the suggestion by the officers, recommendation that CR1 makes a controlled activity pathway for those properties, I think is a reasonable and appropriate response generally. I think we can distinguish Wurua Station for reasons I'll come back to shortly, but in terms of the proposed redrafting of that rule, it would still result in Wurua Station development, or a number of them, requiring consent as a discretionary activity. The reason I say that is I'm referencing the consent notice that applies to the property. The consent notice states that only 50% of the building footprint must be within the nominal building location on the sites that have been created. So if the rule as drafted with recommendation CER1 controlled activity rule was adopted, it would remove that flexibility that exists under the consent notice if you wanted to go through controlled activity status, or would result in people becoming discretionary just because they stepped outside of what was a nominal building platform identified back in 2008. So options, we have a specific rule in the precinct. We have the coastal environment rule that has some clause that recognises at Wurua Station the 50% standard. We go through with the precinct provisions as I have drafted permitted activity status. So the intention for the permitted activity rule was to provide that certainty and to potentially remove an unnecessary duplication of process, given the very extensive consenting background and history relating to this site. The intention was not to make it an easy process. It's intended to be thorough, detailed and robust. There are two certification requirements in the proposed rule. One is around the design elements, and they start with the Wurua Station Architectural Code, and having completed that design approval process through the committee. They also bring in the CES2 Colours and Materials standard. Now that is a little bit belts and braces because that standard effectively is already in the design code for Wurua Station, but it makes it very clear that there is no, that those provisions are being applied to Wurua Station. And then it brings through all the elements that are in the consent notice, brings them to a prominent place within the precinct. It makes it very clear that it's not a light, easy and straightforward process, it's a detailed, comprehensive and thorough process that is to be gone through both in terms of the design components and then secondly in terms of the servicing aspects of the buildings. If this were not to be accepted as permitted activity and controlled activity rules put in place either in the precinct or reverting back to the general one, it's very hard for me to see what difference that process could make to the outcome in terms of what is built on any of these sites. With such a robust framework with everything so clearly specified, I just really struggle to see the benefit of that process other than retaining control to council at the end of the day. And I don't think that's sufficient justification to move something from permitted activity status into a situation where consent is required. So my evidence covers that in a number of places. The evidence in chief really sets out the background to the property. There's a very detailed attachment to that attachment 2, which goes through all the consenting history. There is thousands of pages of documentation. I didn't want to overwhelm you, but there's a full set of plans from off of Miskel that show each of the building platforms, that show the planting, both within the 4,000 square metre areas and the land surrounding that. It is required, and that really rigid framework has been established through that consenting process. So when I approached the precinct, initially I thought of whether Wurua Station actually met and satisfied the criteria for special zone / precinct that this panel helpfully put together as excellent guidance to all those submitters who were seeking something. So that was very helpful. I've been through that. I was originally not convinced that Wirra Station justified precinct. And I looked at how it could be knitted together in amongst exclusions and exemptions to other rules and provisions. That was a failed exercise that just became too fraught and would have resulted in multiple insertions across general rules of the plan, creating exemptions for different things at Wirra Station. So clearly a precinct was and is the preferred and favoured approach. And my approach to that was, well, if we're going to have a precinct, then we need to ensure the provisions are appropriately reflecting the location of the site and the coastal environment. It's not an outstanding natural landscape. It doesn't have those highest level coastal values, but it's at that next level, which is also still important and requires careful and considered management through the planning framework. So in preparing the precinct provisions and the evidence that explains them, I took a very detailed approach to ensure that nothing that would be in place, that is in place currently, current planning framework, that should be reasonably applied, was left off the table. Put it all together to the best of my ability. Permitted activity status is, as set out in my evidence and my rebuttal, justified and reasonable in this instance. We have a differing view over that. I also feel that restricted discretionary activity status is entirely appropriate as the status of that you fall into if you cannot meet the very rigid permitted activity standards. I have a differing view perhaps than what Council's planning approach, but in my view, restricted discretionary activity status is by far preferable to discretionary, not because it leaves something off the table, but because it brings a focus and clarity to what we're going to look at as applicants, as planners processing these applications. It brings that focus. And there's no reason why we can't write provisions that bring that focus when we're preparing plan provisions, when we know the range and nature of effects we're dealing with. So again, I've taken that approach. Mr. Wyeth and myself differ over that. It's quite common in this proposed plan that discretionary activity status is the default if you don't meet a rule or a standard. I have a different view and have applied my view and my rationale for it in respect to these precinct provisions. The other point of difference is around the helicopter landing area. We have an operative plan that has a rule for the activity, landing helicopters, and another rule for the noise associated with it. For whatever reason that's not known to me, the proposed plan does not generally apply an activity status in zones, precincts, and special areas. I found two examples where it has done, and I followed those examples in preparing the permitted activity rule for Wirra Station in the precinct. I genuinely consider that the structure of the Act requires the activity to be given a status and then the standards that apply to that activity to be expressed either in the same place or in a general set of rules such as the noise rules. I've set that out in the evidence and happy to take questions on that. The other matters addressed in rebuttal were really just some formatting and just some detail matters. I've accepted some of Mr. Wyeth's comments there. I've held firm on others. They are less critical than the overall activity status, of course, and the precinct itself, which we're seeking. So I'm happy to take any questions.
Yeah, thank you. Thank you, Mr. I mean, your evidence is quite clear for me. I understand what points of difference between you and Mr. Wyeth. I haven't got any more questions in that regard. I'm assuming you're open to providing some more detail as to how that approval process gets included in the provisions. Have you got any, got any suggestions as to how that might be achieved? You could possibly slip it into one of the definitions, or you could make it part of the R1 rule.
Just for clarification, it is part of Per 2 of the R1 rule. It's clause A.
Let me have a look at that. That's cool.
And then the certification requirement is now at the end of that rule. So Per 2 clause A, the very first item is the,
Process, yeah.
yeah,
We don't know what that design code approval process is. I'm just wondering maybe that could be one of the definitions, you know, because you've got a set of definitions in your precinct provisions.
yes,
And you define, so potentially you could add that to definitions applicable and define what approval process means.
Wonder if,
And then you could just make reference to the consent notice,
I wonder if the,
or we could just do that.
yeah, I wonder if the Leroy design guide, whatever it is, I mean, another option would actually be to append it as an appendix in the district plan. It kind of gets a bit cumbersome to try and put it into a definition because it's actually quite a comprehensive document.
Obviously, I'll give Mr. Wallace the opportunity to comment on that.
Yeah.
But what I think we can do is potentially leave the door open for you when they do approval for 48 hours.
Yeah, I was going to say,
Provide an updated
yes, we
memorandum to Alicia Kate as to how it's some further along. We're going to throw that to you
Yeah.
today.
I was going to ask you that, perhaps if I could provide you with a written response, say by close of play on Monday.
Yeah. We'll say Friday. But
Tomorrow?
But then again, give them the weekend to work on it.
I do need to talk to my clients.
Yeah, sure. And we're not looking for.
No.
We're only looking for some very, very, very specific comments on those matters.
Yeah, I try and keep it to sort of a page at most, including my signature. So yeah, it's brief and succinct, but I'll be interested to hear what Mr. White's got to say about it.
No, only just a detail, and it sounds like I'm picking on provisions, but just the provision for the minor household unit or the minor residential unit. Where does that come in? Maybe that's not part of the consent notice.
no, it does not. Looking across both the operative provisions and the proposed provisions, there is provision for a minor household unit, but lots have to be 1 hectare in area, which seems to me a pretty nominal threshold by which you're above that, you're fine, below that you're not. I mean, where does it even come from? So that provision does not work. We're a station in the lots of 4,000 square metres, but as out in my statements, both of them address it to some degree. The types of houses and the people that are going to live in them here are the types of people that will have a guest wing with its own kitchen. May hardly ever be used, but it will exist. Staff accommodation in a wing, a care person, a caretaker, or they set up the house that they have extended family and they sort of have 2 wings. That sort of dwelling is the type of development that can be anticipated on this site at this point in the market that it sits. They would all fall into discretionary activity status immediately. You put a second kitchen, net kitchen in. I'm really just trying to make reasonable provision for the form and nature of development that we can anticipate occurring here. That's the motivation, and I think the rule, proposed precinct rule, targets that specifically. Yeah.
I had similar questions. There's signalled to be a new some national direction on green plans.
Oh, yes.
Which we don't know.
I've been following that. I can address it briefly, if I may.
Yes, and I had similar questions because the date in which the original development was consented, we didn't have a minor residential wall in our operative plan. It's controlled under an operative plan.
Yes.
And in terms of what you're proposing it to be permitted within your precinct, but it's not actually consented within your original.
That is correct.
Approved consent, so it's not part of this.
So you are correct with that summary, and on the matter of what the government is doing, they have changing the building regulations to allow 70 square metre minor dwelling, and they're also put through an amendment to the Resource Management Act to declare that a permitted activity. I don't know the details of that, how widely that's to apply, but they are pushing that borough pretty far and hard.
Has it proceeded past the press release at this point? Have we seen anything drafted?
Yes,
I mean, we've got lots of things being thrown at us
the
that
building.
are going to become operative
Before you guys make your decision.
Yes. It's been a bit of a moving feast, isn't it? Just another one.
Yeah, I'm pretty sure the building code change has occurred, been passed, and the resource management plan is to follow. Yeah, it's 70 square metres, which is more than their discussion paper, which was around 60 square metres. They've gone to 70.
Well, yeah, we'll see what happens in that space, and that might just answer the question.
That might just legislate that permitted rule we wanted.
Yeah.
We're making some changes to the ESHBL, we haven't seen them yet. And they were promised some time ago, so we'll just see what happens.
Before we close, before I finish speaking, I would really just like to emphasise what a good process this panel and the officers have facilitated. My second appearance before you, first time in person, and that on this matter, differences between Mr. Wyeth and myself are relatively minor.
Yeah, it's good to hear
And
that.
that matters of principle
Yeah.
and practice. They do make a difference. They would make a difference whichever way you fall, but we're broadly in agreement, which is a very positive starting point.
Yeah, well, thank you for that feedback. I mean, we embarked on that Minute 14 process, pretty much a year ago, and council officers were instrumental in helping set up that process. It seems to me that every person who has opted into it has had a positive experience out of it. And by and large, a high degree of agreement between the parties again, these sorts of matters about activity status and some standards. So thanks again for that feedback. It's good to know that that process has worked again. Any other further questions? Now, council officers, Mr. McDonald and Mr. Wyeth, while we have these this here, is there any questions you'd like me to direct to them, or any sponsors that you might think might be helpful?
I think in terms of the helicopter plans issue, there's some work about actually explaining the extent of the issue broadly, not just in relation to Wedera Station, that we probably okay. Is there anything, Mr.
No, I don't think so. I mean, there's other rules in the temporary activities chapter, for example, which haven't been touched on with the Hook's evidence, and there's a bit of interplay we need to consider, which I think you need to come back to and written reply. I've certainly addressed Mr. Hook's evidence in my reply. There's points of clarification that he's addressed, so that they're not necessarily matters of disagreement, for some things like unrestricted discretionary activity status for non-compliance. And with the minor residential unit, I was actually recommending that the 1 hectare threshold wouldn't apply, because I understand it's not livable. But there are, I guess, fundamental differences in terms of the activity status. I'm retaining my position on that, and yeah, I'm interested in ultimately in reply.
Yeah, thank you. So obviously, what we do is at the end of the topic hearing, we get a verbal response. We discuss all the evidence that we've received in this hearing, and then council officers have about 2 weeks or so to provide a written response, and that's going to be publicly available along with when at the same time we get it. I'm sort of thinking that the evidence is so clear between the two planning experts that the response from you, Mr. White, might be you set out your provisions, and then the list that you support, then we have Mr. Hooks there, and then we have something for us to deliver on to. So, on that note, thank you very much for evidence and your attendance in person today. It's always good to see citizens in person. And your answers to some questions.
Thank you for your time.
Nice well.
Wish you all the best for the final day.
Yes.
Is there going to be a celebratory afternoon tea at the end?
Oh, like a cup of tea and a biscuit and roll today.
Mr. White's
I'll look that way around.
Yes.
Dawson show. No, thanks again.
Pleasure.
And so I think our next submitter is a virtual.
Hey, Mr.
I
Sturgis.
was going to say, is that Mr. Sturgis I see in the back of the list?
It is, yes.
Good morning, sir. Welcome back.
Thanks, James.
You're welcome to come up and have a seat here at the submitters table. And I understand Mr. Ryan is online.
Yes, good morning, Commissioners. And also online is Marcus Langman, planner from Christchurch.
Yes, good morning, Mr. Langman. Can you turn your camera on? I don't think we can hear you just yet. Can you say something?
That's now on. Good morning, Commissioners.
Very good. Right, we're all connected. Right, so we're in your. How do you wish to proceed with your submission today?
Look, thank you very much. I requested and was granted leave to be heard briefly in reply or response to a couple of matters, and I'm conscious that this is in reply and therefore want to keep matters fairly tight in terms of timetable. The issues that Lucklaw had requested to be heard on were briefly to respond to issues raised in a supplementary report by Mr. Wyeth for the Coastal Environment Hearing 4, who had filed supplementary evidence on the vehicles on beaches issue after the hearing. And there are a few points arising from that which the submitter respectfully wishes to respond to, and then briefly to address you in relation to some mapping discrepancy issues, which I think have been touched on in earlier hearings, but which I wanted to, I guess, use the sweep up hearing as an opportunity to bring the matter to your attention before final deliberations. Just in terms of the documentation before the panel, Commissioners, there's written legal submissions from me of about 6 pages. There's a supplementary statement from Mr. Langman, planner, dated the 21st of October. There's a 1-page outline from Mr. Sturgis, which John will speak to, and Mr. Sturgis, John, has also produced 4 attachments, which I see are currently being handed to the committee. Just kicking off then in terms of the vehicles on beaches issue, and the panel will recall this issue. It's not an opportunity to restate the case, but rather to respond to issues in terms of Mr. Wyeth's supplementary report. Just in terms of legal issues, I'll just mention the first point at 4A of the written legal submissions, that Mr. Wyeth's report refers to submission 550, and there was submission 585, which had amended 550 and which had been granted as an amended submission filed after the close of submissions date. Secondly, respectfully, Mr. Wyeth's advice to the panel omits to consider or engage with the mandatory imperative in Section 75, subsection 3 of the Act, and this is the one that requires Council as a territorial authority to give effect to a New Zealand coastal policy statement, and I've referred at page 2 of the written legal submissions to the well-known King Salmon statement of the obligation to give effect to that as being a mandatory directive, meaning to implement. And I've referred to subsequent some High Court decisions indicating that that's a fairly firm obligation intended to constrain decision makers. It's not an optional. It's not an optional matter. Next, at subparagraph C of page 2 of the submissions, Mr. Wyeth refers to the potential for other methods, including bylaws, and refers to the NZCPS guidance note. It's accepted that consideration of other methods is a mandatory obligation for the decision maker in terms of Section 32 obligations. However, and in reply, the submitter wanted to make the point that there's really no certainty of outcome in respect of any bylaw process. I should mention that there has been communication with Council's policy manager, Mr. Ackers, after the previous hearing. That's included in the material attachment 4 in the material circulated by Mr. Sturgis this morning. And Mr. Ackers refers to Council's signal that it may initiate a bylaw review process. However, the submitter respectfully has been there before, and I record at the bottom of page 2 and page 3 that the submitter and others have previously submitted in respect of bylaw review issues, only to be informed at the submission stages that the adding to the schedule of vehicles excluded was outside the scope of the bylaw review. And of course, that's subject to a political process that are not in the control of either the submitter nor respectfully in the control of the panel. All the panel has charge of is the ability to influence or make decisions on issues in respect of the RMA. Policy 20 of the CPS also extends to adjacent public land, whereas the current bylaw structure for Far North in terms of the road use bylaw excludes land that's administered by the Department of Conservation. So for Pūwheki Beach, the coastal dune system extends inland on the marginal strip. I note that Mr. Wyeth refers to the effects on archaeological sites. That's a matter that Mr. Sturgis can speak to and is addressed in his slides. The Lucklaw submission is supported by NZHBT. I note Mr. Wyeth refers to insufficient evidence to justify a district-wide rule. It's acknowledged by the submitter that its matters within its knowledge are focused on Pūwheki Beach. However, I've referred to literature from Mr. Taylor, or Dr. Taylor, I beg your pardon, who refers to literature internationally acknowledging that vehicles have an impact, a negative impact on beaches, which is in published academic literature throughout the world. So in my respectful submission, it's not a stretch to say that the issues at Pūwheki are not confined to that beach, or at least it's a reasonable inference that it can be occurring elsewhere, really as a result of the VZ rule and the regional council applying only to below mean height water springs, with the result that if people are to comply with regional rules, they've got to drive their vehicles above mean water springs, which of course is in the region where threatened or endangered birds and other species inhabit in terms of terrestrial ecology. In terms of relief on the vehicles on beaches issue, there's a Schedule 1 to the legal submissions that's been filed in Word, where Mr. Langman has tidied up the cruder drafting which I earlier submitted as part of the earlier hearing, and Mr. Langman has formatted the proposed rule to better fit with the format of the district plan. I mentioned that the relief sought by the submitter is a district-wide rule. If the panel considered that the evidence was insufficient, but was sufficient to support a localised rule, then the drafting handed up in Schedule 1 contains in red the words at Pūwhiki Beach. Of course, if the panel was minded to engage with the district-wide relief sought, then you would simply strike out the words in red. So I just wish to make that clear, that I'm not intending to limit the relief, but I simply hand up an option for the panel's consideration in the event that a district-wide rule is unattractive to you. Lastly, just closing out on terms of mapping issues, this was an issue that was earlier ventilated in the hearing 4 process, and the issue is that some of the ONCs mapped in the PDP don't align with ONCs in the regional policy statement and I think the Northland Regional Plan. And the issue appears to be both the seaward extent and the landward extent of the ONCs. And the letter to Mr. Ackers, which is at attachment 4 of the hand up from Mr. Sturgis this morning, has a description of or a side-by-side comparison of the issue also being manifest at other beaches. So at page 8 of the letter to Mr. Ackers at attachment 4, there's a side-by-side comparison between PDP and ONC provisions in the RPS, and the issue seems to relate to both the seaward and the landward extent, and it may be that the far north mapping has relied on perhaps Lynn's database information, but the issue legally is that if the obligation is to give effect to an RPS, and the RPS is in shape and form in some places marginally different, and of course it becomes relevant if the panel is to engage with submissions both from this submitter and others who are seeking to have beaches declared, for example, culturally significant. So if beaches are to be mapped, in my respectful submission, there's sense in them being mapped in the same way in a consistent manner with regional mapping tools. Those were the matters that I wish to bring to your attention in response. I'd like just to hand over to Mr. Langman in terms of any matters that he wishes to speak to from his circulated brief of evidence.
Thank you, Mr. Good morning again, Mr. Langman. So you've set out a proposed rule. Perhaps maybe you should take us through that.
Yes, sure. So the rule itself is based on C151 from the Northern Regional Plan. C151 deals with two different types of activities. So it deals with a range of so if you may not have that in front of you, but it deals with two different matters. There's a rule that relates to activities within the vehicle exclusion zone, and then there are a number of rule parts to that which relate to sensitive environments within various beaches. So the rule looks to set a mapped vehicle exclusion zone, and within that zone a number of permitted activities that can take place, and so these draw largely on the provisions within C151 within the Northland Regional Plan. So Again, it's not. I think there was a discussion at the last hearing about a simple exclusion or prohibition of vehicles on beaches. One of the things that it's acknowledged is that there's a range of activities that are appropriate in terms of access. And so it's not trying to look to ban all access in terms of use of vehicles, and provides for a number of situations where where access basically can be appropriate. But certainly, given the ecological evidence of Dr. Taylor, as presented at the earlier hearings, it's very much acknowledged that the unrestricted access to the beach is having environmental effects. So in terms of the access, the permitted standards, there's a range there. So provision for access where the only access is to the property via the vehicle exclusion zone. Access is required for launching or retrieving of vehicles at the closest practicable point along the foreshore. And there's just a note that in terms of that provision, there's a note at the bottom of that rule that says that the closest practicable point referred to in per 2 should be no further than 200 metres from any access point on Pūwheke Beach. So the reason for that, the rule in the regional plan is possibly not virus. It talks about to be determined on a case-by-case basis, which is a bit tricky given that that reserves discretion to someone to say, well, is someone at the closest practicable point from the access? So putting a set limit on that provides certainty as to whether someone's permitted or not. So the use maintenance, next permitted standard is the use, maintenance, repair, or removal of a structure, an aid to navigation or infrastructure structures. Access is required for conservation and reserve management activities undertaken by or on behalf of the Department of Conservation. And as you'll know, there'll be, in the case of Pūwheke, there is a marginal strip, and that will be the situation throughout the district in many locations as well. So access is required for environmental monitoring or data collection undertaken by consent holders or the regional council, district councils, university and research institutes, or their authorised agents. Again, that just provides for specific control, and there can be activities like bird life monitoring and things like that, which both district councils and research organisations may seek to want to undertake. Access is required for per 6, so access is required for kaitiakitanga monitoring in accordance with Mautauranga Māori, or access is required for customary marine title group where the only access is via the vehicle exclusion zone. Per 8, access being required for attending to the rescue of stranded marine mammals, again something that's potentially important. Or access is required for the burial of dead animals or marine mammals undertaken by DOC, tangata whenua, local authorities or the delegated agents. Access is required for clearance of pipe outlets, artificial water courses and tidal stream mouths. The removal or recovery of wrecked vessels. Access for dune restoration or enhancement and maintenance projects authorised by Far North District Council, or access for mobility disabilities, surf life saving, or authorised coastal works under the Northland Regional Plan. So that's a quick summary of the rule. And it's intended that if you're not meeting that range of permitted standards, and again, just noting that in the case of Pūwheke and many other beaches in Northland, there's already a vehicle exclusion zone in the regional plan. below mean high water springs. The rule has been drafted to reflect that to ensure ease of signage and non-confusion with what access is enabled, and drafted to be consistent with those provisions in the regional plan. Where access doesn't comply with one of those conditions, it's proposed that vehicle use is prohibited. That's probably really a summary of the plan and the planning provisions. There's an additional policy proposed with that set of provisions, and there's an existing objective which that sits under, which is a broad objective already in the coastal environment, so it wasn't deemed necessary to add an additional objective, and that relates to protection of highly valued areas within the coastal environment. And probably just the last thing to say is that in terms of the rule, we've drafted it. I've drafted it to apply to all of the beaches within Far North District Council. So that's in terms of the greater relief sought in the submission, but noting that it can be confined to the beach at Pūwheke. And if there's anything that you want me to go through in terms of my evidence, I'm happy to do so, if that assists.
Thank you, Mr. Langerman. You said this was based on a Northland Regional Council rule, NRC.
Sorry, that's right, not yes.
Could you just tell me exactly where that is?
C
document?
C1.5.
Oh, yeah, sorry.
Sorry.
C?
C 1.5.1.
5.1.
Yes.
Serotonin rules coastal activities.
That's right. Yeah. So that rule applies to mapped vehicle exclusion zones below the mean high water spring tide mark within the jurisdiction of the regional council. So one of these already applies at the beach at Pūwheke, but there's essentially the area outside of the jurisdiction of the regional council and within the jurisdiction of the.
It's under dredging and disposal.
Sorry?
The rule is under dredging and disposal. That's why I couldn't find it. Okay. Conditional use of vehicles on the foreshore or seabed. That's
yes.
the one.
That's the one. So just as if you have that up now, there's a certain part of that which excludes. So that's sections or clauses 1 to 6, which deal with general environments where vehicle access is excluded, and then 7, which deals with those areas within a mapped vehicle exclusion zone.
Okay. That gives us something to compare it against. So that's got that. So you're giving us the option of instituting a district-wide rule or a mapped Pūwheke beach only. Is that correct?
That's correct. Yes. Yes, I think that. So, in terms of Mr. Wyeth's evidence, he was happy to accept that that in terms of the evidence before the panel, that there was a range of evidence that related to, in his view, specific environmental effects that were occurring at Pūwheke Beach. His position was effectively that that the submitter hadn't provided sufficient evidence to demonstrate that a blanket rule in the Far North should apply.
So yes, I get that. So this rule applies at the moment under the regional plan, coastal plan. And so just remind me, what does your proposed rule control that isn't otherwise controlled by the regional planning board?
Certainly. So this rule applies above the main high water spring tide mark, and Mr. Sturgis will show you some probably some sort of further information on that. But this applies above the mean high water spring tide mark. So in terms of the evidence that was produced by Dr. Taylor, there's impacts not only on the shellfish beds that are within the mean high water spring tide mark, but outside of that, there's bird nesting sites, there's lizard habitat, there's snail habitat, there's vehicles undercutting the dune tow on the beach, all of which occurs outside of the regional council's jurisdiction.
So the area that you're proposing that provides additional control,
yes,
that has to be met.
Yes, that's right. Yes.
Right. So that means if we were to apply it to all beaches, council would need to map each beach.
That's correct. Yes. Yeah.
That would be class on it.
No, I don't believe that that's correct. Yes. No, there's no remapping required because.
Well, I was going to say the controls. Hang on, go see Mr. Lang's trying to answer the question first. So if you are controlling areas above mean high water springs,
yes,
a part of a beach, otherwise,
yeah,
you haven't written in what that area is into the rule, so you would have to map it. Is that correct?
that's correct. Yes.
So somebody has to do an analysis of what parts above mean high water springs should also be subject to this rule.
That's correct. Yes.
It's a mix of subjectiveness and scientific analysis to determine how far above mean high water springs you would take that line, and then you would need to map it. Is that correct?
That would be correct. Yes. Yeah.
So that's what I was saying, is that you would then have to do that analysis for every other beach that has vehicle access. Because you want to determine how many beaches in the far north have vehicle access, and then where would you want to exclude, where you want to move that line, and then you would need to map it.
Yeah, I accept that. Yes, that's correct. Yes.
I just wanted to understand what the implications are. Today, sorry, you can do that for Puriki Beach now as part of this hearing. And do you have the mapping, and do we know where have you mapped it? Has anyone actually mapped it?
For Pufeki Beach?
Yes.
Yes, Mr. Sturgis has included that in.
We'll just see if any other commissioners have any questions for Mr. Langman, and then
yes,
we'll
we'll go through that detail of how you determine that point.
Yeah. Yeah. Sorry, and I'll probably just also note again, reiterating from Mr. Ryan's legal submissions. From my point of view, the option of the bylaw, which is Mr. Wyeth's preferred option, is inherently uncertain. Mr. Sturgis will outline what the opportunities that he's had to seek a bylaw restriction, and I understand that a bylaw review was being looked at, which looked at potentially adding bylaw restrictions on the beach. The difficulty with the bylaw is that it's a different decision-making process compared to a district plan. There's no certainty. It requires political input into that decision-making process, and there's no certainty that such a bylaw will either eventually be promulgated and notified, or adopted by the council. So, in the interim, that inherent uncertainty gives rise to potential for ongoing adverse environmental effects. If a bylaw did eventuate, that may address the situation, but the uncertainty that sits in the meantime is sufficient that that I don't think, in my opinion, it doesn't signify that the council's discharging its functions in terms of protection of Indigenous biodiversity, nor giving effect to the New Zealand Coastal Policy Statement.
Yes, thank you. I've seen there's some evidence provided. We've got ecology, you've talked about Heritage New Zealand, Tonga. In the previous hearing as well, we brought up the lack of evidence from Haitatai Marangai, Manawhenua. I can't see any evidence here of consultation with them about this proposal, which, as we can see with what's been proposed, a significant number of restrictions being placed. And we know that Ngāti Kahu haven't had settlement like the other Muri Whenua iwi. So like Te Onuroa Tohe, 90 Mile Beach, they have special legislation because they've had settlement. Yes. Can you explain why, in terms of the Resource Management Act direction, why they haven't been part of this process, Mr. Langman?
I can't explain why they haven't been part of this process. That's a question for them as a group, as a submitter on the district plan.
But as a planner, in terms of cultural and clear direction under the statute, and that wasn't chosen to be part of the weighting and part of the proposal here as part of your evidence, like your ecologist report, for example. Why wasn't there cultural impact assessment about this?
I'm happy to answer that, and the fact that I did address it in my earlier hearing, that point. So we can go back to that one in the city here.
Sorry, I was just to Mr. Langman as a planner.
Yes, sure.
He understands the weighting of that as part of the planning legislation, and why was it disregarded?
This is not in any way limiting access in terms of physical access. It's simply a limitation on the use of vehicles. So I'm not sure what cultural impacts in terms of access for vehicles that you might be concerned about in relation to this.
I think it's not just the vehicles aspects, it's putting limitations and controls over an area in there that they are mana whenua of and not being part of the process, because there is no report from them that addresses the planning concerns under the Act, because that's not part of the evidence we've received. So essentially they're excluded from the discussion.
No, I don't think that's quite correct. With respect, Commissioner, the ability to lodge a further submission on this has always existed, and that's what the process is in terms of Schedule 1 is for.
But as a planner, part of the evidence to address cultural concerns, you could have requested a cultural impact assessment, and the reasons for that are that you didn't. Again,
I'm not sure what that something like the restriction of vehicles on beaches, what benefit you would have in terms of a cultural impact assessment. The restriction in terms of access is simply related to vehicles. It's not in relation to access to sites of significance to mana whenua. And yeah, so I'm just not sure what that type of thing would give rise to in terms of relevant information.
Okay, no, thank you very much for those answers, Mr. Langman. I think we'll come over to you now. Sturgis to provide your evidence. We've got some, I think you've set out the rule here on this page here. Is that where the mapping should be?
Yes, yeah.
Well, in your hands, you take this.
Yeah, just possibly, well, it's fresh in my mind because I'm not used to this sort of thing. And Felicity's point, the issue was raised, of course, between Aititai Marangi, which are fairly recently formed iwi group, being only creating the marae back in 2014. There's a lot of settling in going on, and we're all trying to assist there with that process. But the earliest submission we made was to show that the request to introduce a VEZ at Pūwheki Beach was made by iwi. Iwi were keen. That's in that, I can get the reference for you, but it's an NRC report where it lists out all the beaches that they're thinking of applying this on. And when that came out, it was always our understanding that the NRC boundary was the back of the fortune, because all the correspondence at that time reflected that. So this later on shift right down at the end of that set of hearings to Mean High Water Springs came as a bit of a shock. And it was, I think, related to the Moana Tatakai Act and issues around that, where iwi then, or council recognised issues in there. So also the submission, so in this set of hearings, you've seen submissions from the 339, which is the Runanga type, more what was the Moana hapu originally out there on the peninsula, which look after the whare and the Karikari Beach. And then you ended up, though, in this set of hearings, it was a subgroup under Mr. Tipene Paul, who was representing the Kaitiaki Trust, a separate trust and a separate group. It's common members, but very much a focus on that matter. And they have been asking to have a say over Pūwheki Beach as one of their submissions in here. So without the panel having ruled on that, it's a bit difficult for us to go and say that this is the group that we recognise. We just, as it is, we typically recognise the elders, the komatua, right? And the ones I grew up there as a young boy, so I do have a personal relationship with some of those that are left. So we're trying to do our best on that front. The reason for including Pūwheki is that at the moment, if you look at Y45 and the treaty settlement process that's being rejuvenated through there is no complaint over those northern beaches at the moment. The complaint is always on the side beaches, the Ranganunu Harbour and Doubtless Bay. And so we're all doing our best as we've been the beach that's more in private hands to make sure that we maintain as adjoining landowners, all our responsibilities that the Conservation Act require of us, so that we don't get added to them, essentially. And so it's an interesting dynamic, that one, but it's not to say that there isn't a very close bond in terms of ideals of what people want amongst the groups. It's just that when it's in amongst a treaty settlement, there's a commercial nature to the whole process as well. And that's what we're trying to avoid, that there's not too much damage as that goes through. Is that a decision?
Thank you.
So I was asking if the landowners, if it has to be mapped, where's the mapping? And I take it that's this map here, is it?
Okay, so which page was that? Which attachment?
So that's part of page 8 of your document, which is attachment number 2.
Okay, so this is a particular, if you have a look at the far right bit of the beach, which is the other side of Pūwheki Hill, right? Then that's where there is no issue, and that's because of the recent Carrington Resort and the remapping there. So just that top right-hand corner, you can see the VEZ exists, but there's no hatch being requested on that beach. And that's because the mapping is modern, and the actual LINS mapped Mean High Water Springs boundary pretty much coincides with the reality today. But if you go to Pufeki Beach, those properties that back onto that have not been remapped since 1908. And so it was 1916, sorry, that 1908 was when the new law came in on how to reserve the land from sale. And in 1916, during First World War, the maps were made on this area on blocks 3 and 4. And they obviously couldn't get access to much parts of the beach, so I think they probably just went up on the hill with the theodolite and came down on the hill and took a guess at where really in those days they were looking at where a sign of seaweed had got to, something like that. And there was no requirement for them on marginal in the middle of the First World War to make an accurate assessment. So I would imagine that both ends of the beach seem to be quite accurate. And the middle of the beach, I would say that position represents, there's quite a big estuary that comes in there, and that probably represented something where it looked like water would get up to in a very high storm tide. And then the shading is someone's just made a wiggly line to represent where the edge of this blue. But there's no coordinates on it, it's just purely a piece of shading on a map. So what we've got marked in there is actually just this error margin that exists between a LINS map and your mapping, which you have recently done in your variation where you put in the flood heights, because that flood height or basis of mean high water 10%. I think that's the modern equivalent mathematically to mean high water springs. So those modelling maps actually that you put in that variation are quite accurate, other than the fact that they were based on Rangaunu Harbour floods, but they're quite accurate to what you see today on the beach. And what we are proposing though is that covering that doesn't cause any problem. It's actually just a mapping area over that part of the beach. And we think in terms of your Felicity's point, not wanting to, remember the DOC have under the treaty principles a say in how this beach is mapped, both from Takatoa and the actual settlement, right, but also Ngāti Kahu, right, in terms of their in principle settlement. And you see the Ngāti Kahu map, when you look at your maps, goes right out to that.
In terms of the part of Pufeki Beach that you would like to be excluded in addition to the regional plan rule, is that
that shaded, which lies between two map lines on your.
We would agree with you, and we would direct the council officers to recommend to the council that they adopt your proposed rule. We would provide this map and say that sort of mustard coloured shading area is to be the vehicle exclusion area.
Perfect.
Thank you. I just wanted to clearly understand.
That's all we're asking.
You've done the mapping yourself.
Yeah.
And that's what you're seeking this rule to do, in addition to the regional rule, which is to also apply to that area as well.
Yeah, and it just tidies up a mapping error effectively that can come in because of the need to, when you're trying to prosecute, you have to go back to the LINS boundary. But LINS say that these seaward side of a Section 58 marginal strip, they deliberately make the boundary wrong so that you know it's not right. That's what they say in their concept. So it's just a difficulty when you're now bringing in these excellent mapping systems, right? But obviously you need a few patches and the ability until some sort of mapping regulation is introduced to the RMA on how you do lay out in a drafting sense this area. And the other thing that was recognised by the regional council was that the actual physical place where mean high water springs or mean high water 10 intersects moves up and down the beach by 40 metres, particularly between summer and winter, right? And in winter, it's hard on the dunes in a pristine beach, hard on the face. In summer, it can wind right back down the beach. So it's that issue that there is sort of, you have to put a shaded width of it so people are aware. But it's this, I think the point that's made by Mr. White is that the public are confused. But that is the issue. They are confused and they're getting angry because they don't know. The police are getting angry because they don't know. Regional council are trying to prosecute, but difficult. So it's just a tidy up.
Okay, I understand that. So thank you. We'll give Mr. White the opportunity to make some comments or ask some questions for us. Obviously, you can lead with and tell me what to reply if you want to have further consideration.
Yeah, I will respond more fully for written reply. But that's useful clarification on the mapping. I was a bit confused around what we were talking about here, and as raised in hearing before, I had some significant concerns about
Yes.
minor rule district-wide, so having more certainty around where this might apply is helpful. But yeah, I think I just need to give further consideration to whether this is just addressing mapping issues, applications, etc. Noting that council has a wider strategy around bylaws.
Yes, okay. We'll leave it to them to get your response. I think that's really us from us. I don't think we have any more questions. Thank you again for providing that extra detail. And thank you, Mr. Lang, for drafting a rule for us to consider.
Commissioners, could I just make one point in relation to the relief? So that the submission's framed in relation to VEZ beaches, not necessarily beaches as a whole. So the regional rule is framed in respect of all beaches, but only some beaches are mapped for vehicle exclusion zones.
Okay.
So the drafting that Mr. Langman has provided refers in the policy to mapped beaches, and so the proposition would be that the district rule emulate the same beaches that are mapped in the VZ provisions by the Northland Regional Council. Not all beaches are mapped. So, for example, 90 Mile Beach is not a mapped beach for vehicle exclusion zones. And I acknowledge the point made by Commissioner Foy that there is a treaty settlement in respect of some of the Tahiku beaches where the Tahiku settlement framework provides for a beach management agency, which is a multi-iwi entity. I'm not aware of any controls having been imposed on by that entity, and as I say, the prominent beach on the west coast of Tahiku is not a mapped VZ beach. So in terms of the mapping exercise, it would simply be extending the VZ control as Mr. Langman has proposed to from the seaward extent of mean high water springs, which is already known and mapped, to a landward extent. In the case of Pufeki, that's easily identified by the boundary of the marginal strip with Lucklaw Farm. So there's an identifiable boundary there that extends to adjacent public lands, and that adjacent public lands is consistent with the policy 20 imperative. There wouldn't be much point in having a VZ over a bit of adjacent public land that is, for example, a cliff, because no one's going to drive on it. So there would need to be some evaluation of the landward extent for other beaches if you were minded to do that as a mapping exercise. But the mapping exercise would be confined to VZ beaches if you were minded to adopt a district-wide control.
Just, I guess, I don't know if it's a question or more of a statement. Mr. Langman talked about the different mechanisms that could be utilised, such as the bylaw. As you'll probably be aware, after this process, when the commissioners make a recommendation to council, it's up to council to decide if they accept or not our recommendations, and council decide if they want a bylaw or just a plan rule. or if they would involve the public more as part of a bylaw specifically about this area, or go out for more public consultation and more of a public targeted forum. So still at any level there'll be political input at a certain stage. So I guess that's up to the council when they decide to vote on the district plan as well, just to note the scope of considerations that elected councillors do have within this policy realm. I think as well the other point that was probably going to be questioned around the practicality of rule is the enforcement. And at Karikari there are the Karikari Kaitiaki, which is a funded community group that have mana whenua that go out and do the community, quote unquote policing to help the community with, for example, issues with people doing skids on the beach or, people doing things that the community aren't okay with. So I guess that would be another question for the community and for council, enforcement of this. How much resource would there be needed to enforce on this beach, or, as you've been asking on all of the beaches, from the district council, or would it more go down to the community? And that's as well why I asked about mana whenua, because they're actually a key part in being kaitiaki of the area and actually looking out for things that might actually have adverse effects. So in terms of that community self-policing per se.
The issue of Pūwhiki is access to the beach, right? And the kaitiaki group typically can only enter at one end and then has to, unless it self-determines it wants to drive, which a kaitiaki group, community group, doesn't really fall under the allowed groups that you see in this plan, have to walk the 3 kilometres. And the issue with that is a safety issue. Most of the people on the beach have dogs, large dogs. If they're there and they're happy to defend themselves. And it's our experience that many have guns as well. So it's not something that you're going to get a council person seriously enforcing. And so the situation is you're familiar with Far North and how this. But the reality is what they like is photos from a long distance, right? That's sufficient. Unfortunately, it doesn't address the people who are willfully breaking the law because they just don't register their vehicle or they cover their plate. And that's increasingly becoming the group that are still left. But most people, I think there's been 400 letters go out from the regional council and 380 haven't come back again in that vehicle. So it's a reasonably effective tool, more than what DOC would ever consider doing because it's not their modus of operation. If they don't have support of the total public, they're not prepared to keep pushing it. But in this case, the birds were the people that were there originally. Mr. Paul in his submissions has made it clear that that's something that iwi would like to see retained. Right? That photo there, I think it's a bit subtle in these, but if you have a look at the one that we presented to the Northland Conservation Board, which was in a big scale, you'll see that the last page in the back there is the Caspian terns on the beach that you get, right? And it's only one or 2 days or maybe 3 days a year that they do it. But when they come, they want the right sand type. They like a certain sort of sand type. And B, they want to make sure that estuary is full of little critters to eat because they're hungry and they're on their way back to Alaska. So there's a variety of animals that if you take the time and you just sit there with a camera yourself and a set of binoculars, you can actually see a huge amount. And we think that's something that in this part of the country, people will come for, and it will provide a tourist base that's sustainable.
Okay, well, thank you. I'm going to end on, I think.
Yeah, Mr. Chair, I just have an inquiry of the panel perhaps about perhaps what you might find useful in terms of forming part of the decision. I'm just looking at the attachment number 3. And if we go through and we see that there are purported areas of notwithstanding the veracity of them, but I think noting that So in addition to that, there is quite a significant amount of erosion occurring on that beach, and that will probably be fairly mobile, and irrespective of whether there's vehicles on the beach, that I suspect that would continue. But I'm wondering, Mr. Chair, whether you might see some utility in identifying where, for example, the marginal strip is, relative to Mean High Water Springs and those locations where they have been marked out.
I think Mr. Sturgis is attempting to do that.
But I think there's probably benefit in seeing the photos. I think provide a different perspective. Yes, from my perspective, and I think that might be more helpful.
Yeah, but I tend to agree. Yeah, I think that would be really helpful.
So perhaps you might wish to request that of submitter if they could do that in a short space of time.
Yeah, so this is asking the submitter if he can give us an accurate marginal strip mapping.
As much as is possible, I guess.
Can we give you to the end of the week to produce that?
I can just do it for you now if you'd like.
Okay, well, at the end of the week, and then you've got all the time between now and then. Okay, we'll request that. Thank you very much, Mr. Mayor. Thank you. And well, I think we'll bring this to a close. Thank you very much for coming back and sending this extra evidence to us. I think it's been quite helpful, and it's been an interesting discussion and clarified the matters for us. So thank you very much again.
Thank you all, and I echo the comments earlier from Mr. Hook in terms of process, and it's been appreciated that you're keeping it local while allowing the likes of me to participate cost effectively, and I commend you and staff for it. Thank you.
Thank you. It's great. Thanks. Okay, so I think we're going to be adjourning for some morning tea. Mr. Sturgeon, you're welcome to join us if you wish. Obviously, we'll talk about the weather, not definitely suspicions. And I think we're going to adjourn until 20 past, where we move on to our next topic.
Stopping the recording.
Thank you.